Let's talk about the Breonna Taylor case, grand jury proceedings, and how secrecy breeds distrust. Because justice matters. Hey all, Glenn Kirshner here. So you've probably seen by now that the grand jury in the Breonna Taylor case indicted only one of the three officers. Essentially, they indicted him for recklessly discharging his firearm, though he didn't hit anybody. They declined to indict the other two police officers who fired that night, including the one who fired the fatal round, killing Breonna Taylor. You know, grand jury proceedings are secret by law. And we have to ask ourselves, how can we have confidence in a secret proceeding, right? Secrecy breeds distrust. Transparency breeds confidence in the outcome. Let's talk for a few minutes about grand jury proceedings, and then let's try to tackle a couple of reforms that can enhance the trust that people have in things like grand jury proceedings when our government undertakes to make these extraordinarily weighty decisions, sometimes life and death decisions, and why transparency is so important. So first of all, I don't want to assume that if you're watching this video, you know anything about how grand juries operate. You may have never served as a grand juror. You may have never been a witness in a grand jury proceeding. So let me just do a minute or two on the nuts and bolts of the grand jury, and then we'll try to tackle some reforms. So the grand jury is an arm of the court. It's not an arm of the prosecutor's office. The chief judge will send out grand jury notices telling citizens that they have to report for grand jury duty. And so grand jurors will assemble and will meet, sometimes once a week, sometimes 3 times, sometimes 5 times a week. And they will sit in a windowless room and they will hear witnesses all day long testify about crimes that they witnessed or that they have information about. And they'll see evidence produced by prosecutors, and they will listen to the arguments of the prosecutors about whether a case has enough evidence to ask the grand jury to vote out charges to indict somebody, or whether the case maybe doesn't have enough evidence to ask the grand jurors to indict someone. So the only people who are allowed inside the grand jury room are, besides the grand jurors, the prosecutor, the witness who's testifying, and a court reporter or a grand jury reporter taking down everything that's said in there. Nobody else can come in. If I'm the prosecutor in a murder case, I'm not even permitted to bring in my lead homicide detective or my lead FBI agent. It's only the prosecutor, the witness, and the grand jurors. There's no judge in there. There's no defense attorney representing the interests of the person being investigated. And that is why there is this saying, and you've probably heard it, that the grand jury will indict a ham sandwich if the prosecutor asks them to. What does that mean? Well, first of all, it's not my experience that a grand jury will do whatever a prosecutor asks them to do. In my experience, for decades appearing before grand juries, they take their work very seriously, and they want to make sure that if they're asked to return an indictment in a case, there's enough evidence for them to do it. However, because the prosecutor is basically running the show in the grand jury, right? Unchecked in the grand jury, some people believe that the prosecutors won't play the evidence straight. What do I mean by that? Some people believe the prosecutors will try to rig the outcome. So if a case is really strong, but a prosecutor for some reason doesn't want the grand jury to indict the case, maybe the prosecutor won't present all the evidence of guilt. Or maybe the prosecutor will make arguments to the grand jury that, the case is really not that strong and you probably shouldn't indict this case. Conversely, if the case is especially weak, some people believe the prosecutor can go in and overstate the strength of the evidence and obtain an indictment in a case where one shouldn't be obtained. So that's where we get the saying that a prosecutor can, ask a grand jury to indict a ham sandwich and they'll do it. That's not my experience. However, corrupt prosecutors can certainly abuse the process. And in prosecutors' offices, just like every other walk of life, you've got the good, the bad, and the ugly. So you do need to guard against corrupt grand jury proceedings. So why are grand jury proceedings secret by law? Because secrecy breeds distrust. Wouldn't it be much better if they were transparent and everybody could see what was going on in the grand jury investigation so they could have confidence in the grand jury's decision whether to indict or not indict a case? Well, let's talk about a couple of really important reasons grand jury proceedings are secret and why I believe they should stay that way. But stick with me, because there are definitely some reforms, particularly in police excessive force investigations, that need to be put in place. Why are grand jury proceedings secret? First of all, it's to protect the people we're investigating. Because sometimes we are investigating somebody and it turns out they didn't commit a crime. And if we were to tell the public, if these were public proceedings, hey, guess what? We're investigating this one and that one and this one, but it turns out they didn't commit a crime or there wasn't enough evidence to charge them with a crime, their reputation has been hurt. They've been damaged and they shouldn't have been. That's one reason grand jury proceedings are secret by law, to protect the people being investigated. The second reason, to protect the witnesses who are called into the grand jury and have sometimes the impossibly difficult task of telling the grand jury about a crime they saw committed. It may be that they're testifying against their friends, their family members, might be their criminal associates because they're a cooperating witness and they've flipped and they're testifying about other members of their criminal gang, for example. We need to protect the identity of those witnesses. And let me tell you a quick story, if you'll indulge me for just a minute. Where I served as a prosecutor was in downtown D.C., 555 4th Street, Northwest Washington, D.C. Our building, 555, had a nickname, the Triple Nickel 555. It had a second nickname that was far uglier, though. Some people called it the Snitch Building. Why? Because we had 5 grand juries that sat in our office, at the U.S. Attorney's Office, all week long, hearing from witnesses in criminal cases. Hundreds and hundreds of witnesses would stream in and out of our building every day to appear before grand juries. We would sometimes have bad guys who would pull surveillance on our building, on 555. They would call it the Snitch Building because that's where the witnesses would go to testify. So we took very seriously our responsibility to protect the witnesses, protect their identities. And trust me, when we got wind that somebody was pulling surveillance on our building, we took care of it and we protected the witnesses. But the grand jury secrecy rules have many, many good reasons to remain in place, to protect the people being investigated, to protect the witnesses who are coming before the grand jury to testify. The problem is secrecy breeds distrust, right? Transparency breeds confidence. So how can we put reforms in place so that when the grand jury does its work, particularly in police excessive force cases, that we, the people, can have confidence in the outcome of that grand jury investigation? 2 important ways, folks. First of all, the prosecutors who are responsible to present evidence in police excessive force cases must be completely independent of the police officers and the police force or the police agency being investigated. You can't have prosecutors who work with particular police officers or particular police agencies and expect those prosecutors to then turn around and investigate allegations of excessive force against those same officers or those same prosecutors, because even if the prosecutors do their jobs perfectly, there is an appearance of favoritism. There's an appearance that, you know what, they're going to end up maybe being a little bit too generous, a little bit too lenient in favor of the police officers or the police agency because of their pre-existing relationship. So the prosecutors who handle these excessive force investigations must be completely independent from the police force being investigated. A whole different agency, in fact, is who should take the lead on excessive force investigations. Second, and this is almost as important and maybe even more important, it's the transparency piece. So grand jury proceedings are secret for good reasons, as we just discussed. However, there are exceptions to grand jury secrecy. Most jurisdictions have rules in place that at the conclusion of a grand jury investigation, the prosecutors can apply to the judge for permission to disclose matters occurring before the grand jury. Now, different jurisdictions have different exceptions in place, and some may have no exceptions at all for disclosing police excessive force investigations. But they should. I would urge every jurisdiction to pass a rule or a law if need be. Usually these are just rule changes to allow for a prosecutor to have the judge, ask the judge to order, disclose to the public all of the matters that occurred before the grand jury in a police excessive force investigation, so the people will have confidence in the outcome. They can scrutinize what evidence was presented to the grand jury about that excessive force incident. What arguments did the prosecutor make in favor of the evidence satisfying the standard to indict police officers if they engaged in excessive force? And if the evidence didn't support it, there wasn't enough to indict a particular officer in an excessive force investigation, the public would get that information as well, and they would get to scrutinize it for themselves. Because, folks, gone are the days that we can rely on government officials to go into secret proceedings and make consequential decisions about we the people, sometimes literally life and death decisions, and have confidence that they're going to do the right thing behind closed doors. Gone are the days we can trust our government officials to do that. And I don't know that we can ever get it back. I don't think we should ever try to get it back. Because secrecy ought to be a thing of the past. Transparency ought to be the rule moving forward. Because transparency ensures or helps ensure justice. And justice matters. Justice for Breonna Taylor and everyone else who lost their lives as a result of a use of force by our law enforcement officers. Those matters need to be fully and fairly and transparently investigated so that we can all have confidence in the outcome. Because justice matters. As always, folks, please stay safe, and I look forward to talking with you all tomorrow.